Hi, everybody. Welcome to the Hammer Museum. I'm Claudia Bester. I'm the Director of Public Programs, and I'm very pleased to welcome you to tonight's Hammer Forum on the upcoming Supreme Court season with Jennifer Chacón, Derek Muller, Kimberly West-Faulcon, and our moderator tonight is Law Professor Rick Hasen. Before we get started, I want to remind you to please silence your cell phones, and please note that taking photographs and video and audio recording are not allowed in the theater, but we are videotaping it, and we'll make that available on our website if you want to share it with other people. I also want to quickly mention some upcoming Hammer programs that you might be interested in. On Tuesday, October 1st, historians Susan Neiman and Brenda Stevenson are going to be here to discuss truth and reconciliation and reparations in post-Holocaust Germany and what the United States might learn from that process as we deal with the legacy of slavery here in our own country. We also have a panel on what would reparations look like on November 12th, also moderated by UCLA American History professor Brenda Stevenson. We're also bringing back our very, very popular Constitution Happy Hour. It's a Friday night happy hour from 6 to 8 with a cash bar. And we'll read excerpts of the Constitution together as a community and participate in discussions led by leading constitutional scholars. And everyone who comes gets a free copy of the Constitution, but you have to buy your own beer. The next Hammer Forum is on October 22nd, and we'll be discussing and reporting on the latest news on impeachment hearings, whatever they might be at that time. We have no idea, but whatever's going on, we'll report on it. We also have upcoming program with Susan Orlean and Roxanne Gay talking about the importance of public libraries. That's on October 2nd. We have Lawrence Weschler coming to talk about Oliver Sacks on November 22nd. And one of the leading curators of photography, Charlotte Cotton, is coming to talk about social media and the surveillance state on October 29th. So if you'd like to receive reminder emails about our upcoming events, please sign up for our email list. You can do that with the ushers out in the lobby. You can always find out more on our website, and you can find a lot of our public programs on the Hammer website under the Watch Listen page as video podcasts. So, on to tonight's program. The Hammer Forum is a monthly series of public discussions about current social and political issues, and it's made possible with generous support of Andy and Bronya Galiff. In today's forum, we'll talk about what to expect in the Supreme Court's new term, which begins on Monday, October 7th. It promises to be a momentous season. Not only does this term overlap with the presidential election year, but the court is also expected to review the DACA program, a New York City gun control law, and cases involving workplace rights of LGBTQ employees, and possibly abortion cases and voting rights issues. So we have lots to discuss. You should have all received some note cards and pencils on your way in. Those are for you to write your questions on for the Q&A period. When we get closer to Q&A, we'll send around ushers, and they'll collect your cards and bring them up to the stage. If you didn't get a note card or you need some extras, you can just raise your hands, and we'll send an usher to bring you more. Please be sure to write your questions very legibly so that our moderator can read them out to the panel. And now I'd like to briefly introduce our guest speakers. Jennifer Chacón is professor of law at UCLA Law School. She was previously the Chancellor's Professor of Law and Senior Associate Dean for Administration at the UC Irvine School of Law. Chacón's research focuses on the fields of immigration law, constitutional law, and criminal law and procedure. She's a co-author of the 2017 casebook Immigration Law and Social Justice, and of numerous articles, essays, and book chapters on citizenship, immigration, border control, and human trafficking. She served on the Executive Committee of the American Association of Law Schools section on immigration, the Ninth Circuit Advisory Committee on Rules of Practice and Internal Operating Procedures, the Advisory Committee of the American Bar Foundation's Future of Latinos in the U.S. project, and the University of Oxford Border Criminology's Advisory Group. After matriculating with a JD from Yale Law School and an AB in International Relations from Stanford, Professor Chacón clerked for the Honorable Sidney R. Thomas of the United States Court of Appeals for the Ninth Circuit. She began her career in law teaching at UC Davis School of Law, and she's held appointments as a visiting professor of law at Stanford Law School and at Harvard Law School. Derek Muller is a professor of law at Pepperdine University School of Law. His research and writing focus on election law, particularly federalism, and the role of states in the administration of elections. He's published numerous election law articles, and his popular writings have appeared in the Wall Street Journal and the New York Times. Before teaching at Pepperdine, he clerked for the Honorable Raymond W. Gruender of the United States Court of Appeals for the Eighth Circuit and practiced as a litigation associate at Kirkland & Ellis LLP in Chicago. Professor Kimberly West-Faulcon is a nationally recognized expert in anti-discrimination and constitutional law who holds the Bradley Chair in Constitutional Law at Loyola Law School in Los Angeles. She graduated from Duke University and Yale Law School, where she edited the Yale Law Journal. After law school, West-Faulcon clerked for the Honorable Stephen R. Reinhart in the Ninth Circuit Court of Appeals. After extensive legal practice, including acting as director of the NAACP Legal Defense and Educational Fund, she joined the Loyola Law School faculty in 2005, where she teaches constitutional law, advanced topics in constitutional law, employment discrimination law, constitutional law rights, civil rights, principles of social justice, and social justice lawyering, and has also taught constitutional law at UCLA and USC as a visiting professor. Her academic articles have been published by the Yale Law Journal, University of Pennsylvania Law Review, UCLA Law Review, Wake Forest Law Review, and the Journal of Constitutional Law. Our moderator tonight is Rick Hasen, the Chancellor's Professor of Law and Political Science at UC Irvine. Hasen is a nationally recognized expert in election law and campaign finance regulation, writing as well in the areas of legislation and statutory interpretation, remedies, and torts. He is co-author of leading casebooks in election law and remedies. From 2001 to 2010, he served with Dan Lowenstein as founding co-editor of the peer-reviewed publication Election Law Journal. He's the author of over 100 articles on election law issues, published in numerous journals, including the Harvard Law Review, Stanford Law Review, and Supreme Court Review. His op-eds and commentaries have appeared in many publications, including the New York Times, the Washington Post, Politico, and Slate. He also writes the often-quoted Election Law blog and has written several books, including the 2018 book, The Justice of Contradictions, Antonin Scalia and the Politics of Disruption, the 2016 books Plutocrats United, and his newest book, Election Meltdown, Dirty Tricks, Distrust, and the Threat to American Democracy, will be published by Yale University Press in 2020, and we've invited him to come back and speak about that once it's published. So now, without further ado, please join me in welcoming Jennifer Chacón, Derek Muller, Kimberly West-Faulcon, and Rick Hasen.
Thank you for coming. Good evening. I'm Rick Hasen of UC Irvine School of Law, and welcome to the 2019 Supreme Court preview at the Hammer Forum. Last year's Supreme Court term was an important time of transition, with the replacement of Justice Anthony Kennedy by Justice Brett Kavanaugh after a controversial and bruising confirmation fight. And it was the first full term with new Justice Neil Gorsuch on the court, who replaced Justice Antonin Scalia. This seemed to put Chief Justice John Roberts as the justice in the middle of the court, and that's one of the things that we'll talk about today. Even as the court decided key issues last term, from partisan gerrymandering to the census, to important death penalty cases and the power of the administrative state, it managed to delay or avoid deciding many other issues. As Claudia mentioned, in the upcoming term, which starts in a few weeks, we may get decisions related to two issues connected to gun rights under the Second Amendment, to the DACA program related to immigration, to LGBTQ workplace rights, with many other issues likely on the horizon, including abortion and voting rights. Many people expect that on these key issues, the court will divide along ideological or partisan lines, meaning a Supreme Court with 5 conservative Republican-appointed justices will have its way more often than the 4 liberal Democratic-appointed justices on the court. But this is perhaps too simple. Last term, we saw some interesting and notable splits between Justices Gorsuch and Kavanaugh, suggesting that at least in some cases, we won't see the court necessarily dividing along the now expected 5-4 party and ideological lines. There's so much to discuss, and what I've asked each panelist to do is to take 9 or 10 minutes, talk about what they're expecting in the term, as well as focus on a key case or group of cases the cases that I've mentioned. I'll then ask some questions, probably for about 15 or 20 minutes. We'll have a little bit of a discussion, and then I will turn to your questions. So if you fill out those note cards, they'll be passed to me. So please keep your questions short, and please keep them questions. And I'll try and get through as many of them as I can. And we're just going to work our way down the line, and we'll start with Kimberly.
Okay, great. Well, thanks so much for having me. I wanted to start by talking about a few of the themes from last term and the upcoming term. And I say for starters that one of the things that I'm concerned about, obsessed with, like to pay attention to, depending upon the moment and my constitutional law geekiness, is how many justices we have on the court who still believe that the line of cases that protect the right to privacy are still correct or are correctly decided. And then along with that, which of the justices and how many justices we have who might be in the camp of being eager to overturn those cases. And those cases refer to right to privacy cases that stem from a 1965 case, Griswold versus Connecticut. Griswold was a case where the court struck down a Connecticut law that made it illegal for married couples to use contraceptives. The second thing that I really can't get enough of thinking about is originalism. I find myself, to the chagrin to some of my students, wanting to come back over and over to looking at originalism and trying to understand it more deeply. In particular, the implications of the form of new originalism that is now going to be practiced by so many of the current justices, original meaning originalism. And the first thing to be clear on, and my students are getting this lesson over and over again, is that new originalism is not the same as your grandfather's version of originalism, which would have been AKA, what did James Madison and Alexander Hamilton think or intend a particular provision of the Constitution to mean? New originalists now call that old originalism. So what I'll be looking for next term is what we are finally going to see with new originalism and when it's put into practice versus it sounding really reasonable and logical as a theory of ascribing meaning. But like many theories, the proof will be in the pudding, and the question will be what its implementation looks like in real-world cases. More specifically, original meaning originalism is that we're going to determine meaning based on looking at dictionaries and legal documents and scholarly writings from the 1700s and 1800s, depending upon the provision, and actually reject the intent of those who wrote the provision as a source of meaning. And even though that is, I think today, fairly described as the preferred theory of the Republican Party and picking judicial nominees and the Federalist Society, the actual number of Supreme Court cases that use new originalism, meaning originalism, cannot just be counted on one hand. It could, in my view, be counted on one finger. It's really DC versus Heller, the case interpreting the Second Amendment in 2008. So that brings me to the last theme that I'll be looking for in comparing the last term with the upcoming term, and it's one I've already hit upon, which is within the Republican-appointed justices, how interested are they in adhering to precedent, and how far and how are they willing to take new originalism? How many of those Republican-appointed justices are willing to join Justice Clarence Thomas, who has repeatedly expressed a willingness to overturn virtually every right of privacy cases, so those Griswold versus Connecticut type cases, that is in the current constitutional law case books. Justice Thomas has also expressed a willingness and interest in revisiting a very important First Amendment libel case, and then cases related to the important doctrine of the incorporation of provisions of the Bill of Rights to apply to states. So as far as the cases, the LGBTQ workplace right cases, there are also cases that revolve around interpretation. So they're another opportunity for me to geek out and be very interested in originalism, because those who describe themselves as new originalists in interpreting the Constitution also self-describe as textualists in doing statutory interpretation. And so what's going to be at issue in these LGBTQ workplace rights cases is the meaning of a particular phrase in a particular statute. It will be a question about the meaning of the phrase "because of sex" in a federal civil rights law that protects workers from discrimination and harassment in the workplace, as well as from working in a hostile work environment. The specific question over which the parties disagree in these three cases, which are actually going to go to the court consolidated into two cases, where one of the employees is someone who was fired because her gender identity does not conform to her biological sex at birth, and the two others are cases where sexual orientation minorities are, and the question will be whether they are protected by and can sue for relief under this civil rights statute, which is Title VII, an anti-discrimination employment law. Title VII, it was initially codified in the Civil Rights Act of 1964, so Lyndon B. Johnson signed it. And its goal primarily was to protect employees from various types of discrimination on the basis of race. And so when it comes to ascribing meaning to a statute, again, it used to be the old thing to look at legislative history. What did the people who wrote the statute think it meant? What did they intend? If that were still in vogue, there would be an interesting tidbit in the history of Title VII's because of sex provision that would make that particularly difficult to use as a source of meaning. The words and the inclusion of anti-discrimination on the basis of sex was added to Title VII by a legislator who strongly opposed the passage of the anti-discrimination law, but the racial anti-discrimination law, Title VII. So the "because of sex" term in the phrase was added to kill Title VII. That was the intent. It was the hope that it would discourage legislators from voting for the provision, so you don't have 1964 original meaning intent on the part of those who codified the "because of sex" language. So the background facts on those cases are pretty straightforward examples of discrimination. Discrimination on the basis of gender identity and sexual orientation. And the question isn't really the facts that are in dispute about what happened. We aren't really there yet. The issue is the merits question of, even if everything the plaintiffs assert happened did happen, do they have a cause of action under this civil rights statute? Does Title VII's language that prohibits adverse employment actions because of sex cover discrimination and adverse actions taken because of someone's gender identity or sexual orientation? So one of the cases is EEOC versus Harris Funeral Homes, and it was a Sixth Circuit case about a transgender woman named Amy Stevens who was fired from her job as a funeral director after she informed the owner that she intended to live as a woman for a year and then began the process of medically transitioning to conform to her gender identity as female. The funeral home director, in addition to making the claim that the "because of sex" language in Title VII does not apply to gender identity discrimination, asserts a religious objection to retaining a transgender employee. The two other cases are about whether or not Title VII's "because of sex" language prohibits discrimination on the basis of sexual orientation. The Second Circuit case is Zarda versus Altitude Express, involving a gay male skydiving instructor who was fired from his job after a female customer complained that Zarda touched her inappropriately and then shared his identity as a gay man who had an ex-husband to reassure her. The Second Circuit sat in en banc and decided that, yes, sexual orientation discrimination was covered and is indeed an unlawful action under the "because of" language in Title VII. Similarly, in an 11th Circuit case, Bostick versus Clayton County, a gay man, Bostick, was fired from a position as a child welfare services coordinator after receiving good performance reviews, but his identity as a gay man was revealed to his employer. So with these cases, they serve up an opportunity for, on the side of those who believe that sexual orientation and gender identity do fall within the terms because of sex. The arguments are ones that fit very well within the broader precedent of Title VII. My take on these cases is that the court has long interpreted, as a matter of precedent, Title VII to be a broad statute, that it overarchingly, if you read the whole text, the idea behind Title VII is to eliminate hierarchy, eliminate discrimination of various sorts. And so when you look at the subparts of what it means to discriminate against someone based on their gender identity, the circuits that have decided in favor of the plaintiffs have said it is definitely part and parcel, that there's absolutely no way to engage in discrimination on the basis of one's gender identity or sexual orientation and not to in some way be considering their sex. And on the other side, what the defendants and the employers' argument seems to be is one that, frankly, resonates in a very old-fashioned way of thinking about anti-discrimination and formalizing an argument that is quite similar to the kinds of arguments that were made in cases like Plessy versus Ferguson and Loving versus Virginia, that if blacks have to sit in a rail car different from whites, blacks and whites are being treated the same, was the argument that the court made in Plessy versus Ferguson. The dissenter in Plessy versus Ferguson said that's absolutely absurd, that the reason the segregation is existing in the first place is to reinforce a racial hierarchy in which whites are at the top and blacks are at the bottom, similarly with Loving versus Virginia. So what I'm looking for with these cases is what the textualists are actually going to do with the case. Will they decontextualize because of sex, take it out of the context of what is overarchingly an anti-discrimination provision, which would make it a pretty easy case. The EEOC has already ruled that these types of behaviors would be unlawful, and it seems like it would really take some gymnastics, but that's quite possible with this court. So we'll see what happens.
Thanks so much. We'll turn to Derek.
Sure. So it's an interesting and dynamic time on the court, given that there are 2 new justices over the last couple of years. And I think one of the things that's interesting is they come to the court, and a lot of this litigation has already been happening for years. Right? Litigation takes a long time before it gets to the United States Supreme Court. And at the time when the litigation's initiated, people think the court looks a certain way. There's Justice Scalia or there's a Justice Kennedy on the court. And now there are different justices on the court. And so I think the litigation we see in the years coming ahead is going to look a little bit different because people are anticipating and seeing what Justices Gorsuch and Kavanaugh have to say. It's worth thinking that last term they actually didn't agree with each other very much. They agreed with one another 70% of the time, which sounds like a lot, but in fact, Justice Kavanaugh agreed with Justices Kagan and Breyer at a higher rate than he agreed with Justice Gorsuch last term. Now, of course, in hot-button, high salience issues, especially the kinds of things we're talking about today, they tend to be 5-4 decisions, and there tends to be a partisan divide, but it's worth looking into the future, especially to see whether or not there's going to be some idiosyncratic positions that some of these justices take out. Justice Gorsuch in particular, I think, has shown himself to be a much stronger defender of criminal defendants and their rights under the Constitution than maybe some might particularly anticipate given his nomination process. So it's worth considering some of those trends in the long term. I want to focus on one case that the court is going to be hearing this year involving the Second Amendment and gun rights called New York State Rifle and Pistol Association versus New York. It's worth thinking that when it comes to gun control in the United States, the overwhelming amount of the discussion about gun control is really in the political realm. It's really left to Congress or the state legislatures to handle gun rights because the Constitution doesn't say a whole lot about it. In fact, the first time that the Supreme Court recognized that there's an individual right to bear arms in the Constitution in the Second Amendment was in 2008 in Heller, in a case where the District of Columbia had essentially banned the ownership of handguns, and the court, in a contested 5-4 decision, relying upon the meaning of the term and as it was understood at the time over a dissent that was interpreting the Constitution and the meanings of the terms and what it meant at the time, concluded that there was an individual right to bear arms and that the District of Columbia essentially prohibiting the ownership of guns was infringing upon that right. A couple of years later, in a case called McDonald versus City of Chicago, City of Chicago had essentially prohibited the use, the ownership of handguns, and the Supreme Court, in a 5-4 decision, said, this right is not just a right guaranteed to, or a prohibition against the federal government, or in that case, the District of Columbia acting. It also extends to all state government laws as well. And again, the city of Chicago had prohibited the possession of guns, and the court struck that down and said, you've infringed on the right to bear arms. That was 2010. Here we are 9 years later. Supreme Court hasn't really spoken on this issue. It's mostly, again, been left to the political process, to the states, to Congress to decide what that looks like. And as you see, I'm sure many people in the audience have strong views about gun rights, gun control. You can see the politicians are sometimes very reluctant to act, or maybe in a lot of cases, we sort of expect that litigation is going to take place. And the Supreme Court hasn't spoken, but that doesn't mean that people haven't litigated this issue. They said, look, there's a Second Amendment right to bear arms. What does that look like? And a lot of people have brought a lot of litigation in the states or in federal courts, in lower courts, saying, I'm a convicted felon, but I've been released from prison. Am I allowed to have a gun, even though the state says no? Or I've been deemed mentally incapacitated, but can I still have a gun? Or can I have an automatic rifle, despite the fact that there's a law prohibiting me from doing that? And the lower courts, for the most part, have sort of kept the status quo. They've mostly upheld sort of existing prohibitions on certain kinds of gun ownership. In certain cases, they've struck them down. And the Supreme Court has sort of let this sort of move through the lower court system over the last 9 years without articulating much else. There hasn't been really a strong force of will from the Supreme Court to go beyond what it said in 2008 and 2010. Because those were two pretty strong bans, right? An outright ban on the use of guns, but they didn't really specify what the rest of that right looks like. So this is a chance now for the Supreme Court to step in, since they've granted certiorari in this case. Because New York has, as a state law, it provides that you can get a license to carry a gun, and that's a pretty difficult license to get in the state of New York. And more common is to get a license, it's called a premises license, which means you can have the gun at home, essentially for home protection, or maybe for a certain handful other use. You're not really supposed to leave the home with it. And in New York City, they have a statute on top of that that said, in fact, the only times that you're allowed to leave your home with that gun are if it's unloaded in a lockbox with the ammunition stored separately, and you're taking it to a gunsmith with permission, you're taking it to a hunting grounds with permission, or you're going to one of 6 or 7 licensed gun ranges in the city of New York. So essentially, you can't take the gun outside of the city limits of New York for any of those other purposes. A lot of folks said, look, there's only 6 or 7 gun ranges in the entire city of New York. We'd love to be able to go to some places outside of the city that maybe are cheaper, or that maybe will provide us more opportunities, and we would just like to have that. We're happy to unload the gun, put it in a lockbox, keep the ammunition separate. We just want to be able to sort of leave the city limits. And so this case sort of goes up now before the Supreme Court, and looking at what the contours of this right to bear arms might look like. And a couple of focuses of the litigation have been the fact that the Second Amendment says you have the right to keep and bear arms. And so thinking, is there some relationship between keep and bear? One is maybe holding it onto yourself, and one of it is carrying it around someplace. Another is there's this precatory language, and this was controversial in Heller, saying that a well-regulated militia, the militia doesn't get as much attention nowadays, but the attention is that the well-regulated, and the notion is that people need to be able to practice or get better at using their guns so they have fewer mistakes, or that they don't accidentally shoot people, and that's a good thing. So this comes up before the Supreme Court now to consider what the contours of this look like, because lower courts have to figure out at what point does the state's interest outright outweigh your individual interest, right? If you've been convicted of a violent felony, we're not going to let you have an assault rifle. Maybe that's one thing, and they say the state's interest is really good there. And in other cases, saying we're going to completely prohibit the ownership of the gun, it's really bad. So courts are trying to figure out, do we try to come up with a balancing test to figure out what these look like? Are there certain sort of clear, defined contours that we can say these are always prohibited from the state, or the state can always enact these laws? Those are the things the lower courts have wondered about, and the things that the Supreme Court has largely stayed away from in the last 9 years. So as this case goes up, and potentially a very significant decision articulating what the scope of the right to bear arms looks like, New York doesn't feel great about its odds, so it amends its statute and says, well, okay, you can now leave the city with it, and you can go to any kind of shooting club, and we've changed the law. So this brings up an exception called mootness, which is there's no live case anymore, Supreme Court. You don't have to hear this anymore. And so sometimes that works. Sometimes the case is moot and we don't want to hear it anymore, but there are also lots of doctrines and lots of exceptions to this mootness doctrine that says the Supreme Court or a federal court can still hear this case. If there's a chance that you go back, we throw out the case, and the legislature repeals the statute and puts the original statute back in place, is that a risk? How serious of a risk is that? Or the litigants in this case said, no, it's not moot because even though I can sort of take my gun, unload it in a lockbox with the ammunition on the side, and drive out to a gun range somewhere else, if I stop to gas up at a gas station outside the city limits, I'm technically in violation of the statute because I've stopped someplace with the gun. So there's a question about whether or not the court chooses to sort of engage in, I think, the hard question about what the contours of the Second Amendment look like, or if maybe there's 5 justices on the court at least who choose, maybe we're going to punt on this issue. We think this isn't the right case, and we'll just let the lower courts and the states sort of figure it out a little bit longer.
Thanks. And I'm going to have to be previewing that case for some students next week, so I'm hoping the court declares it moot before I have to prepare. So but if not, I'll just copy your notes. Thanks. Jennifer.
Hi. I wanted to thank the organizers of this event for inviting me and Rick for thinking of me as well. It's really fun to be here, and I'm really excited to see so many people who are interested in these issues on a weekday evening. I wanted to divide my remarks into 2 parts and talk first about some themes that we might take from looking at the court's term last year and from looking ahead to the term to come. And then I wanted to drill down on one specific case, or a set of cases, actually, which involve the challenges to the administration's rescission of deferred action for childhood arrivals. So I'll start with themes, and one of them is one that's already been touched on, which is the notion of sort of, are we going to see concrete ideological blocks left and right, consistently deciding cases in ways that are incredibly predictable? And the answer is not always, but I think we can also say the court has shifted to the right with the retirement of Justice Kennedy and his replacement by Justice Kavanaugh, and we can expect, I think, that rightward trend to continue in the upcoming term. And I think if we're looking for the center, the person in the middle who replaced Anthony Kennedy, we're not going to be able to look to one justice. And we see swinging happening in many directions. And we've already heard about Justice Gorsuch, who occasionally does a sort of a Scalia-esque move where he sides with criminal defendants when he feels that the government has overreached. And unlike Scalia, we've also seen Gorsuch do that in the case of immigrants in deportation cases, siding with the immigrant against the government when he feels the government has overreached in its application of deportation statutes. So that's unexpected, and it means you don't necessarily get the ideological outcome that you would expect. And Kavanaugh similarly has sided with the liberals in some cases as well. Justice Roberts has not been a strong presence at the center ideologically, so it's not like he has some commitments that come out where he sides with the liberals because they're sort of articulating his sense of what the world ought to look like. But I think he plays a centrist role institutionally. So I think it's when he feels that the reputation, the sort of institutional reputation, the integrity of the court is at risk, that he pops up as somebody who will side with the liberals where he feels like there might be an institutional reason for doing so. And I think the census case might be an example of that, where the administration just did not do its homework in terms of giving reasons about why it wanted to add a citizenship question to the census. And Justice Roberts, at the end of the day, just couldn't get behind the false reasons that were being given to him, and so he voted with the liberals. So I think he does that in a way that I think is meant to try to preserve some sort of institutional integrity. I think there are some other themes we might look to, and one area where there's been a lot of discussion is how this court treats precedential decisions and when it's willing to overturn precedent. So if you listen to a lot of people who covered the court or talk about the court, there's a general sense perhaps that this court is more willing to overturn precedent or move away from precedent. And I think numerically speaking, that's not necessarily true. This court hasn't necessarily overturned more cases than prior courts have, but they do talk about precedent in different ways. And so I think if you look at the decisions when courts are overturning precedential decisions, as they did, for example, in Franchise Tax Board, they're not that concerned with jumping through all the doctrinal hoops that the court typically jumps through when it decides that it's going to overturn a precedential decision. And they're more comfortable saying, well, we just don't think that precedential decision was right anymore, and we're going to overturn it. And that comfort with sort of setting a low bar in terms of what is required for talking about overturning cases, I think think is what gives people unease when they think about cases like the reproductive justice cases and the right to privacy cases that were alluded to earlier, and abortion access more generally, and also a range of other cases where precedent has sort of kept the court steady in a kind of a tempestuous ideological sea, cases like affirmative action cases, for example. So I think that's something to watch in the term to come. And the final issue that I'll flag, because it's an elephant in the room, is just the overall legitimacy of the court, the politicization of the court and its legitimacy, and how the court is contending with that. And so here I can just allude to two simple historical facts, and one is the non-confirmation proceedings for Justice Merrick Garland, followed by the very, very rapid confirmation proceedings for Justice Kavanaugh, notwithstanding the allegations of sexual assault that were made against him prior to his confirmation. And so those two events, I think, really captured a lot of attention, made a lot of members of the public skeptical about the legitimacy of the court as a non-political body, and certainly in the context of some of the high-profile cases that will be decided, will be a burden that the court has to carry around as it makes its decisions, and makes Justice Roberts' role as the keeper of the court's institutional integrity that much more difficult. So now I want to turn to one case that illustrates some of these themes, and that's the consolidated cases that involve challenges to the administration's decision to rescind the Deferred Action for Childhood Arrival program. So this case has its origins in 2012, when then Secretary of Homeland Security Janet Napolitano issued a memorandum that indicated that individuals who were between the ages of 16 and 31, who were present without authorization and had been present since 2007, and who met certain criteria, would be able to apply through the United States Citizenship and Immigration Services to have any immigration action against them be deferred. It's deferred action, a longstanding form of prosecutorial discretion, whereby the agency does not pursue a removal case against you. And so the Obama administration set up this program. Individuals would apply, they would pay a hefty fee, and their application would be screened. The administration would then decide whether to extend deferred action to these individuals, and if they did, the individuals could also apply for work authorization as authorized through statute and regulation, and they could also access driver's licenses, again, as authorized by statute. So there were some benefits that were authorized by statute and reg that people were able to access by virtue of this exercise of administrative discretion, but it was, at the end of the day, a decision about enforcement discretion. There were some challenges at the time to the legality of DACA. Some Immigration and Customs Enforcement agents sued the state of Mississippi, got involved in some litigation. Legal challenges to the DACA program were routinely rejected. So there is not a court that has ever found that the DACA program is illegal. And there's pretty good arguments that the DACA program is legal. So that's the sort of backstory. But we know that President Trump has never been a huge fan of the program or of many of the beneficiaries of it, although he speaks out of both sides of his mouth on this issue. So we know he kicked off his campaign with statements that were sort of loaded with anti-Mexican animus. The vast majority of DACA recipients are Mexican. We also know that he said that he would do something great for these young people, though it's not really clear what the great thing he has in mind is. So he comes into office, and one of his campaign promises at various points in time was that he would rescind DACA on day one. Day one came and went with no rescission, but in September of 2017, Acting Secretary of the Department of Homeland Security, Elaine Dukes, acting pursuant to instructions from Jeff Sessions, indicated that she was using her authority as the secretary to rescind the DACA program because it was illegal. So the administration's justification for rescission that was stated was that the program was illegal. And the administrative record about the illegality of the program is pretty thin. It consists almost entirely of 3 cases that were decided in federal court in Texas and by the Fifth Circuit pertaining to a different deferred action program, the Deferred Action for Parents program, that never went into effect and that actually distinguished the DACA program within the terms of those decisions. So that's kind of the administrative record for the decision that the administration has undertaken. In this way, it looks a lot like the administrative records that has been created in some other cases, including the census case, where it has a sort of dog ate my homework feeling when it gets to the court. And so that is the record that the courts have been contending with, and obviously there were many plaintiffs who were unhappy about this rescission and sued. And they said, you can't do this, you need to give us a reason, you're doing this because you're discriminating on the basis of national origin and race, and you're doing this in a way that violates due process. And district courts around the country agreed. Courts in Maryland, courts in New York, courts in the court in the Northern District of California, all said, you know, you're right. The administration did not do this the way that they needed to do this, so we're going to enjoin the rescission of the program. We're going to stop it. We're going to keep everything in place while we figure out sort of how to evaluate these claims on the merits. The administration really did not like that answer and wanted the Supreme Court to hear this case immediately. So they tried to get the court to take the case early. They tried to speed the case along when the Ninth Circuit was taking a while to decide the appeal, and they tried to get the court to take it early again. The court does not seem particularly eager to decide this case quickly. I think they were hoping, probably like many of us, that the Senate might do something that would make these cases moot so that they wouldn't have to decide it, or that the administration would come to some sort of an arrangement that would be more suitable. That hasn't happened, so now the Supreme Court is basically in the position of having to decide this issue and of having to decide it on a record that's not particularly useful, where it looks again like the administration is sort of making things up and developing post hoc rationale. And so they are in the unenviable position of being a sort of institutionally damaged court that now has to decide this question that in which the fate of many of our friends and neighbors, teachers and students hang in the balance on a record that does not look very good at all.
During the 2020 election.
During the election.
Well, we've now exhausted all the controversial topics. So let me turn to some non-controversial topics. Let's start with the question of abortion. That was an issue that the Supreme Court really assiduously avoided last term, despite the fact that they had opportunities to weigh in. But there was one case where the court issued some temporary or intervened in a temporary way, and it may come back to the court. And this is the June Medical Services versus G case. And I want to start with Kimberly. Can you just give us a quick lay of the land and then have whichever panelists would like to kind of talk about what's the court likely to do here and what does it all mean in terms of reproductive rights?
Sure. So June Medical Services is an abortion provider in Shreveport, Louisiana. And Louisiana is a state that, in addition to having one of the, it seems like a flurry of abortion regulations that are about regulating, banning, really going to a great extreme with respect to early pregnancy regulation, maybe even prohibition of terminating pregnancies. The June case is actually of the older variety. Before the many 2019 regulations that seem to be, we're going to stick it to Roe v. Wade and do it quickly and hope that it will be completely overturned. June is one of the more subtle attacks on, or subtle methods of trying to decrease the number of abortion providers in a state by regulating the facility itself. So it is quite literally the same law that the court has held to be a violation of the due process clause, a law that failed to meet what is actually a lowered standard of review compared to what Roe v. Wade had, but something called the undue burden test. And so in 2016, after Justice Scalia passed away, so there were only 8 justices on the court, there was a 5-3 case where the court said that requiring abortion providers to have admitting privileges at a hospital that's a certain number of miles from where the procedure takes place constitutes an undue burden, because essentially it's an unnecessary medical regulation, that abortions as a medical practice and a procedure are so extremely safe that doctors who perform them don't need admitting privileges at nearby hospitals. And so again, the crux of the 2016 holding was that such a regulation being unnecessary, and possibly the purpose being to decrease the number of abortions that take place, constitute an undue burden on the fundamental right to terminate a pregnancy still protected in Roe v. Wade. So for Louisiana to put in place a law that is essentially identical is another way of thumbing your nose at precedent. So we're back to this question about precedent. And so June Medical is that case. The medical center asked for the Louisiana law, the requirement that these abortion providers get these admitting privileges to be put on hold, for there to be a stay until the Supreme Court decided whether or not they would take the case. So in February, that stay was permitted. And so what was in the news was the fact that Justice Roberts voted with the quote-unquote more liberal justices and granted the stay. But that is really getting too far ahead of anyone who would think that the right to terminate a pregnancy is in any way safe. Instead, it's a procedural matter, and really what is going on, big picture, seems to be that a continuation of the death by 1,000 cuts at Roe v. Wade. Even that stay decision had a dissent from Justice Kavanaugh, of all people. You would have thought after that messy confirmation hearing, he kind of would have laid low a little bit, but instead he provided a explanation of why he would not have granted the stay, which kind of shows his hand a bit on how he interprets that 2016 ruling. Again, it's a cut to that opinion and a willingness to not apply precedent to even consider hearing a case where you so recently have held that the very same kind of regulation violated the Constitution. To even consider it suggests to any legislature that we can go back at this apple over and over again. And Justice Kavanaugh's opinion really did not take seriously the 2016 ruling. Instead of saying, well, the reason, in giving his reason for not providing the stay, he said, well, we should wait and see what happens and see if the 3 of the 4 remaining abortion providers in the entire state of Louisiana, whether they can get the admitting privileges. So it's a prove the negative sort of test, which is wholly absent from that 2016 ruling. So this is another theme and something to watch for. If you do have the opportunity to read the opinions, see what the precedent is, how much and how willing are the justices to stick to what those cases say? Or are we in a new realm where just disagreement or just I wasn't on the court then will be enough to revisit a case? And writ large, wherever your personal views or moral views on an issue like abortion are, there's this bigger question about just the rule of law, the continuity in precedent. I mean, why we sit here and what we do for the most part is to tell you, well, this is what the court has said in the past, and this is what precedent is. And so it is a really major theme, even aside from just these cases. How are these justices going to treat past opinions, even ones from 2016?
And Justice Breyer and I think Justice Kagan both indicated in cases having nothing to do with abortion but having to do with overturning precedent that abortion is on the line. So do you both think that we're likely to see the court take this case or one of the other cases? And if so, does this mean death by 1,000 cuts? Is it hard to say what we're going to see?
You never know. I mean, I think there were a lot of conservatives and a lot of folks in the pro-life movement who were very excited when Planned Parenthood versus Casey went up to the Supreme Court. They said this is the chance to overturn Roe v. Wade.
This is 1992.
1992. And it didn't turn out that way at all, right? So I think anticipating what's going to happen in the abortion cases is sometimes a little tricky. In this case, it's interesting. I think, getting back to Jennifer's earlier point about precedent, you used to have to sort of run through a number of things. Oh, this is why, if the precedent's long-standing, the longer standing the precedent, the more likely you are to overturn it, or the harder it is to overturn. Of course, it's ironic to then say, oh, this case was only decided 3 years ago, so no one's really relied upon it. When if it was 3 years ago, you might sit there and say, well, wait, what's changed in 3 years? Well, the personnel in the court, and that's, I think, one issue about how we sort of decide what precedents are important enough to keep or which ones aren't as important. The one thing I would add is it seems like the states are sort of preparing for what happens if the abortion issue is removed from the Supreme Court. That is, the Supreme Court says, you know what, the federal Constitution just doesn't say much about it. And the states, it's sort of in your realm. That's why states like Louisiana or Missouri or others have enacted fairly significant restrictions on abortion. In contrast, New York enacted a statute that was very permissive of abortion. Iowa and Kansas Supreme Courts have found the constitutional rights in their state constitutions guaranteeing abortions, the right to abortion. So there's a number of things that are occurring at the state level, sort of divergent trends that are trying, I think, to wrestle with what this is going to look like in the future.
Let me ask you, Jennifer, based on what you were saying about Chief Justice Roberts, one thing I've heard people say is Roberts is a very savvy person. If he wants to protect the Republican Party, death by 1,000 cuts is a better strategy than giving Democrats a campaign issue of overturning Roe versus Wade. Do you think that plays into how justices or how Chief Justice Roberts might be thinking about these issues, or about any of the justices, not necessarily about to psychoanalyze him? How much does the practical political situation matter?
I think they would tell you that it shouldn't really matter at all to them and that that's not what they should be doing when they're deciding these cases. How true that is, though, I think is difficult to say. I think there may be reasons aside from this sort of purely political calculation that might motivate Roberts to opt for the death by 1,000 cut strategy, and part of it has to do with sort of his vision of the court as sort of an institutionally respected apolitical branch. And I think the sort of head-on overturning of Planned Parenthood versus Casey, because Roe really is not the legal standard that we use in abortion cases anymore post-Casey. But I think the sort of head-on challenging of that standard is not really his style in some senses. And part of that has to do with not making the court the lightning rod for these highly controversial decisions, especially when you have such nice tools, as we've seen for getting to the same result, empowering states to try more restrictive legislation and giving them some room to run with more restrictive legislation in a way that I think makes those who are opposed to abortion or want more restrictions on abortion feel like this has actually moved the needle in terms of what states can do to regulate. So I think he's savvy enough to know that the court probably both looks better and is able to obtain a fairly good result both politically and ideologically in terms of what he wants to see in terms of federal abortion regulation by doing it this way.
One of the interesting aspects of a case that was decided at the end of last term, a case called Rucho versus Common Cause, which was the partisan gerrymandering case out of North Carolina, was that case, in fact, overturned a 1986 case called Davis versus Bandemer, which said that federal court doors were open to hearing these kinds of cases. But Roberts never said it. It certainly overturned it. It certainly was a holding that was in conflict. But so that does give a sense that he's concerned at least about appearances of yet another precedent that would be overturned.
He's also used the overturning of precedent in order to try to bolster court credibility. We saw that in Trump versus Hawaii, where he used the sort of symbolic overturning of Korematsu, I think, as a way to sort of take the edge off a decision that looked in many ways to be sort of sanctioning of certain kinds of discrimination by the administration.
And that was, of course, interesting because nobody was asking for
Nobody was
Korematsu to be
asking
overturned, and it wasn't an issue in the case. One of the things Kimberly mentioned earlier in one of the discrimination cases involving the LGBTQ cases was about the clash between anti-discrimination law and religious rights. But those are not the only kind of religious rights cases that the court has been hearing. And there's a case that hasn't gotten a lot of attention but seems to be a pretty important one. It's the Espinoza versus Montana Department of Revenue case, where the issue of religious freedom and schools is coming back. And I'll start with you, Derek. What's at issue there, and where are the fault lines?
Yeah, so this is a long-standing fight about public funding of schools and education and how much or what the boundaries are when the state wants to fund religious education or doesn't want to fund religious education. So Montana had a tax credit program where if you contributed $150 or up to $150, you could get a tax write-off if you gave it to a scholarship account, and then the scholarship account would give that to students that these nonprofits and the scholarship entities wanted to give to students to essentially use for their education. And so there was one such program run by an entity called Big Sky that wanted to provide scholarships to low-income students or students with disabilities, and they said, we're going to give it to you whether it's public school, or whether it's private schools, whether they're religiously affiliated or not. And then there was a challenge to this, and the state of Montana looked at it and says, no, we have a amendment in our state constitution. These are sometimes called Blaine amendments because they were popular in the late 19th century after Senator James Blaine of Maine. And they essentially, these amendments in many state constitutions that prohibit states from using public funds to essentially for some kind of sectarian purpose or for religiously affiliated schools. So pretty overtly prohibiting the use of funds for that basis. So they said, well, we're going to have a rule that says you can use the funds for non-sectarian schools, but you can't use them for religiously affiliated schools. And there was litigation in the state court to say, no, well, we want to use it for religiously affiliated schools. It goes up to the state Supreme Court, and the state Supreme Court looks at it and says, no, we have a constitutional amendment on the books that says we can't use it for that basis. And when we look at the law that Montana passed, the legislature passed, it really doesn't make any discernment between what's a sectarian purpose or not, and we as the Montana Supreme Court aren't going to make that determination. So we're going to essentially strike down the whole program. We're going to end this program of sort of scholarships for students. So the challenge now goes up to the Supreme Court. And the notion is, well, what is the appropriate relationship of state funding for things that can benefit religious entities? You can think about the two sort of extreme examples, right? No one, or I shouldn't say no one, very few would say the state should be sort of hiring and running an established church in the state. But no one, I think, would oppose the fact that if a church is on fire, and you call the fire department goes and puts out the fire at that church just as if it would any other house. So the question is, like, what are sort of the middle lines? And there are a couple of Supreme Court cases that have tried to draw these lines in the harder cases. One is called Locke versus Davey, where Washington had this scholarship program, and you could use the money for essentially any school. It could be a religious school, it could be a private school, it could be a public school. The only thing is you couldn't get a theology degree using that money. And the Supreme Court upheld the program, and they said, look, there's a little bit of sort of play in the joints of these election clauses in the sense that the First Amendment sort of doesn't require the state to give out the money in the first place. It's actually allowing you to go to religious schools. The state has an interest in not funding its clergy, we think. This is sort of a unique separation of church-state issues. So in that case, the line drawing was okay. A few terms ago, the Supreme Court decided a case called Trinity Lutheran, where the state of Missouri had a program to get recycled tires for your playground. And a church in Columbia, Missouri that ran a daycare center said, we'd love to replace the gravel on the ground with recycled tires. And the state said, well, we can't do that because we don't give money to religious entities under our state's Blaine Amendment. And the Supreme Court said, no. If you're dealing with kids getting scraped knees, you can't pick on churches, right? You can't discriminate against the church, and you're sort of singling them out for bad treatment. And there was a lot of fighting and a lot of other in footnotes and in concurring opinions and dissenting opinions about how far this principle goes. And that's where this case is. This case is sort of squarely in that zone between Locke v. Davey and between Trinity Lutheran to try to figure out what that appropriate line drawing looks like.
Am I remembering right that Justice Gorsuch declined to join in one footnote, and that was the footnote that said, all we're doing here is about playgrounds.
Yes. Yes.
Just asphalt on playgrounds.
Yes.
Not even monkey bars on playgrounds. Yeah. Come on.
Yes, he didn't want to sign on to that footnote because he wanted to make a broader holding. I mean, what is very striking, but again, part of this theme of what was before is not now, is that Trinity Lutheran and this other line of cases are an opportunity for a certain number of justices, and it seems like it's a majority, to really put out a new version of a reverse discrimination claim. Like, we're used to now seeing reverse discrimination claims that are whites alleging race discrimination because an anti-discrimination statute or an affirmative action policy harm them, or men asserting the same with respect to an effort to include women. And in law schools and constitutional law classes, we are still teaching a kind of what Scalia would say is an old footnote about, well, the role of the court is to protect discrete and insular numerical minorities, those groups who can't protect themselves through the political process. But what many of the justices are writing about in these opinions is that there is discrimination against Christians, a group that is not a numerical minority. They're a majority religion in this country. And so the stakes are very high in Trinity Lutheran, and some of the dissenters were saying it took a case that was about the Establishment Clause. And the whole idea behind the Establishment Clause is to not fund the playground, no matter how many knees get scraped. Because when you fund the playground, you're inadvertently funding the church. It's not like going to put out the fire, because when you fund the playground, then you can buy more Bibles. And if we're going to have an established separation of church and state, you have to protect the Establishment Clause. But instead of, and this is what Justice Sotomayor is saying in dissent, that the court majority in Trinity Lutheran takes an Establishment Clause claim and makes it a free exercise claim and says, and some of the justices literally say it discriminates against Christians to protect the establishment or protect us from the establishment of religion, that enforcing a state prohibition against paying for something that is religion discriminates against Christians. And that's a really new way of conceptualizing discrimination or oppression, that a failure to fund is discrimination. Whereas Locke v. Davey, it's a person getting a theological degree. It's not a church. And so that was also part of the line drawing. So you're absolutely right. Like, where these lines are going to be drawn is a really key question as we look at these cases going forward. And it's also significant how the justices write about these things, because you could decide these cases in a way that did not continue to separate our people and give Christians, I mean, I am a Christian. I've been on airplanes where people are telling me, fellow Christians, we're under attack. People are discriminating against us, and people earnestly believe that, and it's because of the language that Supreme Court justices are using. They're not just saying there's a violation here. They're telling people Christians are experiencing hostility, and I think that's a theme in these religion cases that's separate and distinct from the substance. There's this dialogue and discourse of Christians are under attack, they're the victims of discrimination.
I want to turn to your questions that I think they're going to be collecting the note cards. Someone's going to be coming around. So I'm going to ask one more question as those cards are collected. I'm going to direct this to Jennifer. Sometimes we get repeaters at the Supreme Court, cases that come back. The one you mentioned, the Franchise Tax Board case, I think was 3 times to the Supreme Court. Another one that's coming back is a case called Hernandez versus Mesa, which is about federal officers violating constitutional rights, but it comes up in a very unique circumstance. So if you could just describe that case and what's at issue there.
Sure. So this is a case, the facts take me back to my hometown of El Paso, Texas. And in that city, which is right on the border, on June 7th of 2010, a Border Patrol agent, Officer Mesa, shot and killed a 15-year-old Mexican national named Sergio Hernandez, who was standing on the other side of the border, and allegedly he and his friends were throwing rocks at the Border Patrol agent, and the Border Patrol agent responded with gunshots, and Hernandez was killed. And his family wanted some sort of compensation for this, and so they sued, and they alleged that the actions violated due process, and that they violated the Fourth Amendment, that it was an unreasonable seizure and unreasonable use of deadly force, and that the officer was not protected by qualified immunity because it was clearly established law that you can't respond to youthful rock throwing with deadly force, and that therefore he was entitled to compensation. And the way that you get compensation against a federal agent is under Bivens, right? There is no statute that authorizes compensation for this tort. And so you look instead to a 1971 case called Bivens versus 6 unnamed federal agents, which says that there's an implied right of action, that when an individual's constitutional rights are violated by a federal agent, that you have the opportunity to sue them for damages. And so that was the nature of the Hernandez suit. So they're trying to get damages from the Border Patrol agent for this action, and they're saying it's clearly established violation of the Fourth Amendment, it's a violation of the Fifth Amendment, and you should pay damages to us. You're not protected by immunity. And it goes up before the Supreme Court once, and in the course of the time that this is being litigated, the court decides another case, Ziegler versus Abbasi, which deals with immigration detention that happened after September 11th. And in that case, again, the immigrant detainees who were mistreated in the course of immigration detention tried to bring a Bivens action. They said, we want to sue these federal agents for their actions. And the court in Abbasi said, we're not going to just go willy-nilly extending implied rights of action every time you're challenging policy decisions. We need to make sure that when you're allowed to sue under Bivens, that it's the kind of case where Bivens is meant to operate, and that it is a context where Bivens has previously operated. So in this case, the Supreme Court, when it got the Mesa case, it said, we need you to answer this question sort of as a precursor to or related to all these other questions about whether Bivens really applies here at all. So go back, and they took it back down, and the Fifth Circuit, when they looked at the issue again, determined that Bivens doesn't apply in this context. That is to say that because this is not the kind of context where the Supreme Court has typically applied Bivens, and because there are all manner of special circumstances that make this a poor kind of case for the application of Bivens, that this is not the kind of case where an individual can claim an implied right of action and get damages against a federal officer. The plaintiffs here have argued there's nothing unusual about this case. This is an excessive use of force case. It's very straightforward. A Border Patrol agent stands and shoots somebody, and you should just apply the standard. And the response has been, this is not the usual case because it crosses the border. It's extraterritorial, it involves issues of national security and foreign diplomacy, and therefore is not the kind of case that's a run-of-the-mill sort of Bivens action case, and therefore we shouldn't apply Bivens in this context. So that's the case, and I think it's a case that has tremendous significance, particularly at this time where we see all manner of power granted to Border Patrol officials on our southern border, particularly being exercised against many people who are coming and seeking asylum. It is a hot time on the U.S.-Mexico border, and an interesting time for the court to potentially be saying that there's really no recourse when Border Patrol agents use their power in certain ways against Mexican nationals or other non-citizens who are on Mexican soil.
Thanks for that. So we have a little over 15 minutes left, and I have probably 20 questions. So we'll do a lightning round. There's some great questions here. I'll start with a really easy one. Is it feasible if Democrats win back Congress, and I'd say the presidency, to add more liberal justices to the Supreme Court? Court packing.
Oh, go ahead.
I think you have huge political problems. Maybe others disagree. I think people view 9 sort of as somewhat sacred for some reason, so I think that's a huge political hurdle to get over. Another is practical. In order to get through, you need the House and the Senate, and you need, actually at this point, 60 votes in the Senate to get over the filibuster, unless you also independently abolish the filibuster. So that's another added conversation to have about what it looks like. So in my judgment, I think it's a very hard thing to do, not impossible. But
There's nothing in the Constitution that prohibits it.
That's right.
There are a number of questions here about DACA, and so I'll give one of them. If the Supreme Court rejects protection of DACA, what legal recourses and options will DACA renewals have in 2020? What about for those who are now on DACA? What's the status going to be? What's the world going to look like?
So if the Supreme Court decides that the administration is justified in terminating the DACA program, then the administration can do what it wants with the DACA program, right? So that means that they could decide that the program is over, and they could do that in any one of a number of ways, right? They could say, we're going to, as they originally proposed, we're going to wind it down. We're going to let you apply for one more 2-year renewal if you're in the 6-month window, and then we'll sort of let you fall out of status over a period of time. That was their initial proposal in September of 2017, so it might look like that. It's a proposal that sits ill with the notion that it's an illegal program, since it perpetuates the program for another 2.5 years, but it's something they proposed. So there's also the possibility that they will try to devise other forms of relief for certain DACA recipients. It's not been an administration that's been working on creative forms of relief for individuals who are out of status. It's quite the contrary. They've been kind of creatively trying to find additional ways to remove individuals who are out of status, including stripping away previous commitments to other forms of sort of enforcement priorities, and giving much greater discretion to individual immigration and customs enforcement officers to make decisions about who to put in proceedings. And so I'm pessimistic, given who's making the immigration decisions, about what this administration will do for DACA recipients if the Supreme Court decides to go along with the notion that they have the power to do this. There is the possibility, I always chuckle when I say this now, there's the possibility of congressional action in this regard. It's a very politically popular program with a very politically sympathetic group of people, and there is massive support across the country for something, some sort of legislative solution to this, for extending some form of relief up to and including citizenship immediately for individuals who currently have deferred action. So it's not out of the question that the legislature could step up, but it's unclear to me that they're going to do so in a timely fashion. And so let's be clear about what this means. This means that people who currently have work authorization, have been working sometimes for years, have college degrees here, have student debt here, have families here, would be told essentially, you're now fair game for removal, and by the way, we have all your information. Thank you for filing for DACA. And so I think that's the worry that people have as we come up to that decision this term.
Okay, I've got a softball question here. How might the potential impeachment of Brett Kavanaugh impact the court's upcoming term? So for those of you who have not heard, recently, just over the last week or so, a new book has come out about Justice Kavanaugh, which claims that there was another incident involving sexual harassment, and it was rolled out by the New York Times in a kind of controversial way. And so there's talk again, and Democratic presidential candidates are talking about should Kavanaugh be considered for impeachment? Where is this going? Is this going anywhere?
Nowhere. It's going nowhere. I mean, the fact that President Trump has not been impeached for, the Emoluments Clause violations that took place the day he came into office. I mean, just as a starter, and because impeachment is a political process, in contrast to the question we were just engaging with, I would see no political will whatsoever. I'm a little perplexed why the people running for president would jump out there on this, because to get the votes to impeach a Supreme Court justice over perhaps lying to Congress would open up an entire can of worms, in the sense of, we also have another justice who sits on the court, who brought him up tonight, Justice Clarence Thomas, who denied sexually harassing Anita Hill. Would there be the political will to go back and do that? Would you question whether a justice lied about something rather small during their confirmation process? There seems to be historical precedent for only impeaching judges when they have engaged in some sort of corruption. And Samuel Chase's early impeachment over what seemed to be a substantive interpretation of the Constitution was unsuccessful. And I think since then, most of probably even the members of Congress and the House of Representatives would see it as untoward to really go after a justice short of them engaging in something that's along the line of bribery and crime. It seems to be one of these jobs that once you get it, you really have to almost engage in a form of some kind of criminal behavior for me to think that that would really be politically viable.
Criminal behavior in the context of the job that you're, or in the
After
context
you
of-
have the job, right? New criminal behavior, not criminal behavior that preceded your confirmation hearing.
I mean, one answer to why the presidential candidates are saying that is because they're trying to get votes from reliable Democratic voters in the presidential primary.
Well, I think they asked, Jared Nadler, the chair of the House Judiciary Committee, where an impeachment inquiry would start. And he said, I think there's essentially no appetite from anyone in the House to do it. It's essentially presidential candidates advocating for it. So impeachment obviously needs a majority of the House. And yeah, there's barely a majority of Democrats in the House interested in investigating President Trump. So you've got to get through that. And then, of course, removal requires the 2/3 of the Senate. Now, of course, you can do it, and you can sort of cause political chaos on the court, but that's sort of its own sort of different issue about investigations or having hearings and things like that. And I think there's really no political will in the House.
So one more related question there. In the event that Justice Ginsburg retires or passes away, God forbid, it says, prior to the 2020 election, do Democrats have any viable avenues to delay the nomination of a new justice until after the election? Isn't that the so-called Biden rule?
Yes, I think there's a rule for that, right? Right?
Well, we follow the precedent, right?
We follow the precedent of Merrick Garland.
So do Democrats have any political tools that they could use?
No, not. I mean, they don't control the Senate, and there's, I think they would probably make a lot of noise about, isn't this just like Merrick Garland, and shouldn't we wait for the election and see what the American people have to say about their political preference for the next justice? And I think that would have about this much power with Mitch McConnell, and they would proceed.
So one of the things we saw in the 2016 election was that people who thought the Supreme Court was a major issue, were motivated to vote on that basis, were much more likely to support the Republican than the Democrat. And so I wonder, as the court becomes more conservative, whether we'll see this asymmetry kind of dissipate and see more activism on the part of the left about the Supreme Court. We'll have to come back in a few years and see if that happens, but I think that's tied in there. I want to come back to the question of precedent. This person asks, liberals worry now about precedent, but doesn't it work both ways? Didn't Brown versus Board of Education overturn Plessy, and wasn't that a good thing? I remember Dean Erwin Chemerinsky, who was our boss at one point, saying that justices believe you should not overturn precedent except when you should. Is that the rule?
Well, there actually is a doctrinal rule. There's precedent. There used to be precedent as to the factors you consider when you overturn precedent. And I think that's the point you were making earlier, that it has never been precedent that you simply overturn a case based on believing that it was incorrectly decided. Because the problem with that is the justices on the court have very different theories about how you ascribe meaning to provisions of the Constitution. So that would quite literally mean that every time a justice is added to the court, all the cases would be susceptible to being overturned. And that, as a matter of continuity of law, is just mind-blowing. I have a hard time even saying it, because that's not the kind of country we're supposed to live in, and it's not the kind of law Justice Roberts wants to tell us the U.S. Supreme Court provides us, because then the court is more a political body that the rules can just change depending upon who's there. And so the factors that are in precedent to consider an overturning precedent were actually touched upon in cases like Brown versus Board of Education. Did the case before rely on facts that we now know to be incorrect? Did the case before rely on law that we now know to be incorrect? Is the reasoning in the case flawed in some way? Was there some degree of reliance on the case, which is what the court said in Planned Parenthood versus Casey about Roe v. Wade, that there had been generations of women who had come to rely on the right, and that there had not been a change in law and it wasn't obsolete. In contrast, Brown versus Board of Education overturned a highly illogical opinion, Plessy versus Ferguson, that I referred to before, and the court explicitly said in Brown versus Board that it was taking the position that a lot of the facts and the way the Plessy court had conceived of the psychological impacts of segregation were now we know to be incorrect. So there is some continuity in the big major cases, the jokes aside, that the justices really have historically tried to take precedent seriously. Justice Scalia being a really unique and special example. Justice Scalia would be highly sarcastic and negative about cases with which he disagreed and precedent, but he would still apply them because he believed in the principle of stare decisis. And so that makes him very different from Justice Thomas, who really does a big belly laugh at the idea of stare decisis. And as Justice Scalia said of him to a biographer, it's reported, Justice Thomas doesn't believe in stare decisis or the principle of precedent, period.
Let me push back slightly on 2 points. So one is, I think, a lot of those, I think you're right, that there's a lot of doctrines that we can kind of walk through. And I think there are challenges to say how concrete are those doctrines when it comes to precedent, and how malleable are they, right? To talk about, how much reliance is there? Whose reliance are we talking about? What are the facts? Which facts are we looking at? So I think there's a lot of questions about, despite the fact that I think the Supreme Court rightly has a lot of these tests, sometimes it doesn't always feel like the tests are necessarily being applied in the most consistent way. I think that's one challenge that the Supreme Court is coming to terms with, which is to say, if we're sort of going through this sort of dance every time we're trying to overturn precedent, maybe it's not worth it necessarily. Second, Justice Thomas, so he had a really interesting concurring opinion, and actually it was an entirely unnecessary opinion, except for him to make this point this term, which is it's that he doesn't necessarily he would adhere to precedent unless it's demonstrably erroneous, and so it's a little beyond erroneous, which is this. Sometimes, the Constitution is not the clearest thing in the world, and even the strongest originalists admit to that. And James Madison uses a phrase called liquidation, which is maybe over time with enough practices we sort of adopt a meaning and recognize an understanding. And Justice Thomas writes, he says, you know what? He's more radical than most in saying when it's demonstrably erroneous, I would overturn it. I'd throw out all those factors. But he's willing to accept that maybe there are certain circumstances where if he looks at it, he says, maybe I just don't know, and we just kind of stick with the best answer we've got over time. But in this case, he didn't even overturn the precedent, right? He sort of goes on this whole excursion about when he's going to overturn precedent. But again, I think this gets to the larger theme of the turn, which is a lot of other separate opinions from a lot of justices talking about what precedent looks like. Anticipating Roe v. Wade, anticipating some maybe big cases coming down the road.
And I think the questioner is absolutely fair to point out that, people use the legal arguments that are most useful to advancing their cause. And at the moment, precedent seems to be something that liberals hang on to, in part because that may be all that stands between them and the overturning of some precedent that they care about.
Well, we're almost out of time, and I've got great questions here about the constitutionality of confiscating assault weapons to qualified immunity, to a whole bunch more. But I'm going to ask instead, what keeps you up at night about the Supreme Court? So take a question from an answer from each of you, and we can end on that happy note. Too hard of a. Should we go back to qualified immunity?
No. What doesn't keep me up at night about the Supreme Court? I guess I'd say I would go to just core principles, because what keeps me up at night is the core principle of are we going to live in a free country with freedom, liberty, and the opposite of liberty is tyranny. And the basic lesson in constitutional law as to why we have separation of powers and we need the Supreme Court is so they'll protect us from tyranny from the executive branch and the legislative branch. So if the court pitters away its institutional integrity and puts itself in a position where the American public doesn't believe in it anymore, and the American public is willing to let a president, liberal or Democrat, or a Congress, liberal or Democrat, pack it, add and make it a court with 30 people and one that changes with every presidential election, then we won't have the court to be the check we need it to be on exercises of executive power that go too far or exercises of legislative power that go too far. So that is really my big concern, that we will lose so much faith in the court that the court won't be able to do its important job of protecting our freedom.
I think the next time there is a president of one party, a Senate controlled by the other party, and a vacancy with maybe less than a year before the election. The last time a Supreme Court justice was confirmed under those circumstances was Justice Clarence Thomas, back in 1991. So it's been a very long time since that's happened, and I think when we think about political polarization or the stakes of the Supreme Court or the incentives the Senate has to act on nominees, I think to the extent that there's a vacancy that happens early in a president's term or in a term where that president then wins re-election, continues on, I think prolonged vacancies and perhaps some of the problems that come with that and determining whether or not we can end certain kinds of partisan gridlock will, I think, be a major, major question next time around.
I think I'm the outlier constitutional law professor that doesn't lay awake at night worrying about abstractions. I am kept awake at night by the almost 700,000 DACA recipients. I'm kept awake at night by Sergio Hernandez's family. I'm kept awake at night by lots of things, which are lots of people whose questions are coming before the court. But I don't put this all at the foot of the court. We have a political process where there are lots of accountable actors, or ought to be. And I think we need to sort of squarely confront the injustices that are happening around us. I worry. What's keeping me up at night right now? Asylum seekers at the border, family separation, kids in cages. Those things keep me up at night. And a system and process that validates those procedures is a broken one. So I am kind of constantly thinking that we need to think about political solutions to these problems, right? Different executive, different members of the Senate, different members of the House, and the courts matter to that. But the courts really are, the least dangerous branch in some ways. And so I really think that we need to think about the court in connection with all of these other actors when we think about the questions that are coming before them, and that we need to think harder about how our institutions treat people. And that's sort of what keeps me up at night, the worry that we're not focused enough on how institutions are treating people in this moment.
Well, I failed to end on an uplifting note.
Yeah, that's me. Then you asked the wrong person.
Should have gone the other way. Please join me in thanking this dynamite panel.